Welcome back to my channel. I'm Skybridge, and today I bring a comprehensive analysis of the procedural issues on state abandonment of witnesses in the Senzo Meiwa trial. The pursuit of justice for Meiwa, however, has unfolded amidst a labyrinth of procedural errors, witness inconsistencies, and strategic gaps, many of which have undermined both public confidence in the legal process and the strength of the state's case. This provides an exhaustive analysis of procedural missteps and state decisions to abandon or decline, calling certain witnesses. These issues in aggregate form some of the gravest weaknesses in the case against the 5 accused men. Drawing from a wide array of contemporaneous media reports, legal commentary, and court proceedings up to August 2025, the analysis goes beneath the headlines, probing not just what happened, but also how the trial's intricate internal workings and omissions have shaped its trajectory and what they portend for its ultimate outcome. The report is organized according to the major procedural and evidentiary challenges that have weakened the prosecution's case. The first and foremost are the persistent postponements and adjournments, the most glaring procedural weaknesses in the Meiwa trial. These delays stemmed from a diverse set of causes, from defense requests for further evidence, disclosure to logistical delays around witness transport, defense counsel changes, and disputes or crises involving witnesses and the accused. Key delays include the complete restart of the trial in July 2023, following the ill health and ultimate reassignment of then-Judge Momela, which effectively wiped much of the previous progress. Multiple sessions lost to defense requests for further documentation and disclosure from the state, such as critical cell phone data and AVL, automatic vehicle locator, records of police and private vehicles, used around the time of the incident and arrest, judicial concerns about the short daily court hours, with court opening at 10 a.m. and closing at 3 p.m., leading to +2 to 3 hours that is lost purely for no apparent reason. As pointed out by legal analyst Mpumelelo Zikalala, these adjournments were not always artificial. Some were necessitated by unavoidable processes like seeking Section 205 subpoenas for AVL data, as required by telecommunications regulations, however. At points, postponements have bordered on abusive, with the presiding Judge Rotha at one point decrying requests for additional time as an abuse of the system. Repeated restarts and elongated adjournments triggered significant procedural drift. The original urgency of witness recollections faded, risks of witness memory decay grew, and the defense had increased time to probe the state's mistakes and gaps. The cumulative effect was a striking judicial inefficiency, exacerbated by the absence of any statutory or enforceable trial duration limits in South African law. Crucially, each delay not only stretched public confidence thinner, but also potentially gave rise to gaps in the process that could arise if the accused were to appeal the trial's outcome. Let us now take a look at Section 174, Discharge Application. Its use, rationale, and funding barriers. Section 174 of the Criminal Procedure Act allows defendants to seek a discharge if, after the state closes its case, the court concludes there is insufficient evidence to support conviction. The anticipated or actual lodging of such applications has become a critical inflection point in the Meiwa trial, shining a harsh spotlight on the state's procedural discipline and evidentiary depth. In August 2025, shortly after the state announced the closure of its case, all 5 defense teams indicated plans to institute Section 174, applications to have the charges against their clients dismissed. The arguments center on 2 interrelated sets of alleged deficiencies. Number 1, procedural deficiency. The state's investigation and subsequent prosecution have left critical gaps in chain of evidence, failed to call all relevant and available witnesses, including those present inside the house, and that key forensic steps were mishandled or omitted. Number 2, substantive deficiency. Much of the testimonial and forensic evidence is either circumstantial, inconsistent, or rendered unreliable due to the above procedural errors. The Section 174 applications have not themselves escaped procedural controversy. Funding for the extensive preparation required became a major sticking point, with Legal Aid South Africa, which supports all 5 accused, refusing to pay for more than 2 hours of preparation time. Even as some advocates indicated 4 weeks, were needed to properly prepare the applications. As a result, at least one advocate indicated, they would lodge the application without full financial support, while another, for accused 5, declined to proceed, planning instead to present the defense's case directly. This mirrors an operational struggle that is as much about the administration of justice as it is about substantive merits. The Section 174 process's prominence is in itself an indicator that the state's evidentiary and procedural strategy has provided the defense with openings to argue that the case does not even meet a prima facie threshold, chain of evidence integrity, and forensic shortcomings. Central to any criminal prosecution is the maintenance of a robust, well-documented chain of evidence. The Maywa trial, however, has become a textbook study in how lapses here ripple through the entirety of a case. Here are the principal failings. Crime scene contamination. The initial crime scene was, by several accounts, left unguarded and unsecured for hours after the shooting. Sergeant Thabo Mosia, the first crime scene expert, only arrived at around 12:20 a.m., more than 4 hours after the shooting. His testimony revealed swabbing errors, critical entry points, such as the kitchen door alleged to be the intruder's entry, were not properly sampled for trace or gunshot residue evidence. Evidence not treated as suspect. Mosia further admitted under cross-examination that the people in the house, including the Kumalo family and Maywa's friends, were never treated as possible suspects, meaning that items like crutches, allegedly used to strike an intruder, were not taken as evidence, and the occupants themselves were not swabbed for residue. Late reporting. The murder was reported to police 4 hours after it occurred, a fact that compromised the reliability of initial evidence and allowed for possible contamination or removal of physical evidence. These failings deprived both the state and defense of key evidential touchstones. They precluded definitive reconstruction of the crime, allowed contradictory accounts to persist, and ultimately fueled the broken evidence chain. Argument repeatedly made by defense attorneys. Section 205 and AVL data, modern procedures, old bottlenecks. Access to digital evidence, especially vehicle movement and cell phone metadata, has become increasingly central to modern crime investigations. Section 205 of the Criminal Procedure Act allows law enforcement to subpoena such data from telecommunications or other service providers. However, in the Maywa trial, delays in obtaining, validating, or disclosing crucial Section 205 material added yet another layer of procedural weakness. Key procedural steps and issues. AVL, automatic vehicle locator, data delays. The defense repeatedly requested AVL records showing the movement of police and other vehicles involved in the arrest and transfer of the accused. The state was often forced to seek postponements to secure records. Via Section 205, subpoenas, as private service providers only release such data upon receipt of a valid court order issued by a magistrate. Incomplete or missing data. It was revealed that some vehicles involved no longer existed, having been written off in later accidents, necessitating further documentation, death of drivers supporting photo albums, and related reports before AVL are related. Movement data could be provided and properly scrutinized. Procedural complexity. The 2023-25 period saw the digital Section 205 subpoena system being introduced in South Africa, including platforms for cross-sectoral rapid requests and responses between police, prosecutors, and banks for financial crime. However, criminal investigations like Maywa's remained partially hobbled by legacy processes, such as paper applications or delays in digital onboarding by key providers, which further stymied timely evidence access. Abuse concerns. Legal and privacy experts raised broader questions about potential abuse of Section 205 procedures and insufficient record keeping, noting that such subpoenas can be granted by magistrates or judges, often without robust oversight, raising risk for constitutional rights and evidentiary robustness. The procedural hurdles around AVL data and the slow pace at which the state acquiesced to defense requests for such evidence has become a case in point for critics claiming that the prosecution neither planned nor adapted sufficiently to the defense's digital age. Those are some of the highlights of the many gaps in the state's case. Why has Thabo Mosia chosen to treat the crime scene the way he did? Is there any cover-up? There are many questions and answers in Maewa's case. Will Senzo Maewa get justice? Drop your thoughts in the comment section down below. Thank you ever so much for watching. If the video is informative, kindly smash the like, share, and subscribe. I'll be back soon with part 2. Bye.